Supreme Court just dropped their gun decision this morning, which, according to Sheldon Whitehouse, radically increases the probability that they're going to drop the abortion decision tomorrow morning. Perhaps, I mean, you know, those who think that the Supreme Court is not a political body are living on another planet. And these guys are very political. Today is the day that the Senate is going to vote on some minor, marginal, around the edges gun control. But I'm guessing that this decision is going to blow that up. I'm guessing that the Republicans are going to use this decision as an excuse to say, oh, wait a minute, we got to go back to the drawing board. And there's no doubt in my mind that the timing of this decision and that legislation is no coincidence, or its ability to blow up that legislation. Similarly, tonight is going to be perhaps some of the most damning testimony, or this afternoon. It'll be from 3 to 5 Eastern time, noon to 3, or noon to 2 Pacific time, right after we get off the air today. That the hearings, the January 6th committee hearings, are going to be extraordinary in that they are laying out the case for Donald Trump trying to corrupt the Department of Justice, which, by the way, is the exact same thing Richard Nixon did, and it's why his Attorney General, the head of the Department of Justice, John Mitchell, went to prison. And so, you know, this is going to be a big deal tonight. But tomorrow morning, if the Supreme Court drops the abortion decision, is there going to be any conversation about it? Who knows? So anyway, here's what the Supreme Court said about guns this morning. Right now, most states issue concealed carry permits so that you can carry a concealed weapon in public. In 7 states, you have to show a need or a justifiable cause for carrying a concealed weapon in public. And those states are, where did my list go? California, New Jersey, Maryland, Massachusetts, and of course New York, which is the law that got struck down this morning. In all the rest of the states, you apply for a concealed carry permit and it's granted to you. Right here in Oregon, if I wanted a concealed carry permit, I just apply to the state and give them some information and they say, okay, cool, here you go. But in these 7 states, which by the way, are among the states with the absolute lowest levels of gun violence. In these 7 states, you have to say, well, you know, I need it because, you know, I'm in a business where I might get shot at. I have a pot dispensary and we take cash to the bank every night. I have a jewelry store. I have, you know, whatever. You have to have a reason. And what the Supreme Court said essentially, and by the way, they invoked the 14th Amendment, the Equal Protection Clause on this, in addition to the Second Amendment. And keep in mind, the Second Amendment, which starts out, you know, a well-regulated militia being essential to the security of a free state, that well-regulated militia part always was the core of the Second Amendment until 2008, when Justice Scalia in the Heller decision said, that's a separate part. And we're going to ignore that because there's no longer a well-regulated militia in the United States. There used to be these state militias. Now they're the National Guard, and that's not really a militia, and quack, quack, quack. And so the whole militia part we can throw out, and we'll just pay attention to the second half of the sentence, which is complete BS, but Scalia did it. And so now the court is building on that, saying, well, if we're not paying attention to the well-regulated militia part, we're only saying that the right to carry weapons shall not be abridged, then the Second Amendment's no different than the First Amendment, which guarantees your right of free speech. Now, yes, there are some limits on free speech. You can't yell fire in a crowded theater. But those limits have to do with place and circumstance. In other words, crowded theater. And so if states going forward want to regulate guns, they can't do it based on who you are, unless the standard is absolutely not subject to discretion. In other words, If I'm applying for a carry permit and I say, I need it because I'm a talk show host, and talk show hosts have been assassinated, it's up to the state to decide whether that's strong enough a reason. In other words, it's discretionary. Some bureaucrat has to make a decision. But if I live in a state where the law says if you've been convicted of a felony, you can't carry a weapon, and I've been convicted of a felony, which, by the way, I've not, but and I had been, then there's no discretion, right? No bureaucrat can say, well, yeah, he was, but we'll give him a permit anyway, or no, he wasn't, but we're going to hold back. No, there's no discretion. So what the Supreme Court ruled today is that states may limit who can carry a handgun, but only in ways that are clearly defined and that don't allow for the discretion of individual bureaucrats. Now, Stephen Breyer, in his dissent, said, quote, in 2020, 45,222 Americans were killed by firearms. Since the start of this year, 2022, there have been 277 reported mass shootings, an average of more than one per day. Gun violence has now surpassed motor vehicle crashes as the leading cause of death among children and adolescents. Many states have tried to address some of the dangers of gun violence just described by passing laws that limit in various ways who may purchase, carry, or use firearms of different kinds. The court today severely burdens states' efforts to do so. It invokes the Second Amendment to strike down a New York law regulating the public carriage of concealed handguns. In my view, the decision rests upon several serious mistakes. And then he goes on to lay them out. Among others, that the New York law is 100 years old. And suddenly we're figuring this out? By the way, tomorrow is the 1-month anniversary of the Uvalde mass shooting. It's pretty incredible. Justice Thomas, who wrote the decision today, the gun decision, writes, the Second and 14th Amendment protect an individual's right to carry a handgun for self-defense outside the home. Do you see any of that language in the Second or 14th Amendments? I don't. He goes on to say the constitutional right to bear arms in public for self-defense is not a second-class right. We know of no other constitutional right that an individual may exercise only after demonstrating to government officers a special need. How about driving a car?